What's up? What's up? I know it's been a minute, so let me get on back to it without delay. So my content's for educational purposes only. Can't stress enough for you guys to do your own research. Praise my content. Find any errors, throw it in the comments. None of us have been alive long enough to know all that transpired in the past, and none of us can live long enough to know all there is to learn. Okay. So, as I just stated, it's been a little minute since I posted. Um, so I'm gonna finish, you know, reading the UCC connection to our slavery. Okay, so when I left off, I read the two paragraphs on the Uniform Commercial Code. I'll be starting out reading about contract or agreement. Okay. One difference between common law and the Uniform Commercial Code is that in common law, contracts must be entered into knowingly, voluntarily, and intentionally. Under the UCC, this is not so. First of all, contracts are unnecessary under this new law. Agreements can be binding, and if you only exercise the benefits of an agreement, it is presumed or implied that you intend to meet the obligations associated with those benefits. In other words, if you accept a benefit offered by government, then you are obligated to follow to the letter each and every statute involved with that benefit. Let me read that again for y'all. If you accept a benefit offered by government, then you are obligated to follow to the letter each and every statute involved with that benefit. The method has been to get everyone exercising a benefit, and they don't even have to tell the people what the benefit is. Some people think it is the driver's license, the marriage license, or the birth certificate, etc. I believe it is none of these. Interesting. Let's see where this goes. Again, this is the first time I will have read this document in its totality, and I chose to share it with you guys. So, it goes on to read, I believe the benefit being used is that we have been given the privilege of discharging debt with limited liability instead of paying debt. When we pay a debt, we give substance for substance. If I buy a quart of milk with a silver dollar, that dollar bought the milk and the milk brought the dollar. Even exchange. Substance for substance. Substance for substance. But if I use a Federal Reserve note to buy the milk, I have not paid for it. There is no substance in the Federal Reserve note. Let me read that again for y'all. Where was I at? Okay, but if I use a Federal Reserve note to buy the milk, I have not paid for it. I've been telling y'all, Federal Reserve note is a debt instrument. It equates to what is owed. This is why you cannot own any property. One of my next videos after I finish this, I'll be talking about how and when all property was vested with the state, with the government and or the states. So you can't own it. This is why you get the deed. The deed equates to a mere user. When you buy a car, do you get a deed for the car? No, you get title to that property. Let me ask y'all this. Since when did that change as it relates to a home? Let y'all ponder on that. Anyway, there is no substance in the Federal Reserve note. It is worthless paper given in exchange for something of substantive value. Congress offers us this benefit. Debt money created by the federal United States can be spent all over the United States of America. It will be legal tender for all debts, public and private, and the limited liability that you cannot be sued for not paying your debt. Let me read that again. I reiterate things and enunciate things for the benefit of the viewers. Hopefully you guys are paying attention so you can catch these jewels. Debt money created by the federal United States can be spent all over the United States of America. It will be legal tender for all debts, public and private. And the limited liability is that you cannot be sued for not paying your debt. So now they have said, we going to help you out. You can just discharge your debts instead of paying your debts. When we use this colorable money to discharge our debts, we cannot use common law. We cannot use a common law court. We can only use a colorable court. We are completely under the UCC, using non-redeemable, negotiable instruments, and we are discharging debt rather than paying debt. See, for those that's wondering, why is he going through all these changes just to read this document? Because I have other subsets of knowledge, prerequisite knowledge, that this is relative to, and I'm learning. See, what you guys are seeing is you're seeing me mentally connect dots of other information that is relative to what I'm reading to you guys. This is why, when I make reference to something, or I enunciate, or point something out, or reread something to you, take it for what it's worth. If you know, you know. If you don't, start looking this stuff up, so you can understand what's really going on instead of focusing on the insignificant while expecting to benefit. Remedy and recourse. Every system of civilized law must have two characteristics: remedy and recourse. Remedy is a way to get out from under that law and you recover your loss. The common law, the law of merchants, and even the Uniform Commercial Code all have remedy and recourse. But for a long time, we could not find them. If you go to a law library and ask to see the Uniform Commercial Code, they will show you a shelf of books completely filled with the Uniform Commercial Code. When you pick up one volume and start to read it, it will seem to have been intentionally written to be confusing. It took us a long time to discover where the remedy and recourse are found in their UCC. They are found right in the first volume at 1-308, which is the old which is the old 1-207 and 1-103. Now, remedy. The making of a valid reservation of rights preserves whatever rights the person then possesses, and prevents the loss of such rights by application of concepts of waived or estoppel. UCC 1-308. Okay. A lot of you guys probably aren't familiar with that, but for those that are, this is probably nothing new to you guys. I mean, this is one of the first things I learned, when I started studying more science. It is important to remember when we go into a court that we are in a commercial and international jurisdiction. Again, it is important to remember when we go into a court that we are in a commercial international jurisdiction. If we go into a court and say, I demand my constitutional rights, the judge will most likely say, you mentioned the Constitution again, and I'll find you in contempt of court, which will leave you totally taken aback and confused. You know, let's get into it though. It says, then we don't understand how he can do that. Hasn't he sworn to uphold the Constitution? The rule here is you cannot be charged under one jurisdiction and defend under another. For example, if the French government came to you and asked where you filed your French income tax in a certain year, do you go to the French government and say, I demand my constitutional right? No. The proper answer is, the law doesn't apply to me. I am not a Frenchman. You must make your reservation of rights under the jurisdiction in which you are charged, not under some other jurisdiction. So in a UCC court, you must claim your reservation of rights under pursuant to their UCC 1-308. Again, that is the old 1-207. It's been amended and revised. UCC 1-308 goes on to say, when a waivable right or claim is involved, the failure to make a reservation thereof causes loss of right. The bars its assertion at a later date. You have to make your claim known early. Further, it says the sufficiency of the reservation, any expression indicating an intention to reserve rights, is sufficient, such as without prejudice. Whenever you sign any legal paper that deals with Federal Reserve notes in any way, shape, or manner under your signature right without prejudice, UCC 1-308, this reserves your rights. You can show at 1-308 that you have sufficiently reserved your rights. It is very important to understand just what that means. For example, one man who used this in regard to a traffic ticket was asked by the judge just what he meant by writing without prejudice UCC 1-308 on his statement to the court. He had not tried to understand the concepts involved. He only wanted to use it to get out of the ticket. He did not know what it meant. When the judge asked him what he meant by signing in that way, he told the judge he was not prejudiced against anyone. The judge knew that the man had no idea what it meant and fined him an additional $25 for a frivolous defense. You must know what it means. Without prejudice, pursuant to UCC 1-308, when you see without prejudice UCC 1-308 in concertion with your signature, you are saying, I reserve my right to be compelled to perform under any contract, commercial agreement, or bankruptcy that I did not enter knowingly, voluntarily, and intentionally. And furthermore, I do not and will not accept the liability of the compelled benefit of any unrevealed contract or commercial agreement or bankruptcy. I'm gonna read that one more time for y'all. And I urge anybody that plans to use this to write this down. I'm gonna speak clearly I'm gonna speak audibly clear, so that way you guys can write down exactly what it said. Okay. When you write or when you see without prejudice UCC 1-308 in connection with your signature, what you're actually saying when you write that is the following. I reserve my right not to be compelled to perform under any contract, commercial agreement or bankruptcy that I did not enter knowingly, voluntarily, and intentionally, period. And furthermore, I do not and will not accept the liability of the compelled benefit of any unrevealed contract or commercial agreement or bankruptcy, period. Actually, Actually, it is better to use a rubber stamp because this demonstrates that you had previously reserved your rights. The simple fact that it takes several days or a week to order and get a stamp shows that you had reserved your rights before signing the document. Okay, note to self, I got 5 stampers. I need to get a 6th because that I don't have. So I'm going to have that within, I guess, about a week's time. All right, so what is the compelled performance of an unrevealed commercial agreement? When you see Federal Reserve notes instead of silver dollars, is it voluntarily? No. There is no lawful money based on House Joint Resolution 192. So you have to use Federal Reserve notes. Compelled. You have to accept the benefit. The government has given you the benefit to discharge your debts with limited liability, and you don't have to pay your debts. How nice are they? How nice they are. Excuse me. But if you did not reserve your rights under 1308, you are compelled to accept the benefit and therefore obligated to obey every statute, ordinance, and regulation of the government. Excuse me. At all levels of government, federal, state, and local. Federal, state, and local. Okay. If you understand this, you will be asked to explain it to the judge when asked. Explain it to the judge when asked. And he will ask, so be prepared to explain it to the court. You will also need to understand UCC 1-308. The argument and recourse. If you want to understand this fully, go to a law library and photocopy these 2 sections from the UCC. It is important to get the Anderson Uniform Commercial Code Lawyers Cooperative Publishing Company edition. Oh my. Let me check to see if that's the one I have. Yeah. Let's see. Give me a second. Let me make sure I got. This one. Give me 1 second, y'all. 1 second. Oh, okay. It's over there. 1 second. Let me go check this shit. Okay, eyes back. All right, so this is not the one. Okay, let me outline this. Okay. Okay, so UCC 1-103. So let me look that up and read that for y'all. 1-103. Look. 1-103. 1-103. Okay, here we go. All right. 1-103. It says construction of Uniform Commercial Code to promote its purposes and policies, applicability of supplemental principles at law. A. The Uniform Commercial, excuse me, y'all, I don't know what's going on with me tonight. A. The Uniform Commercial Code must be literally construed and applied to promote its underlying purposes and policies, which are 1. To simplify, clarify, and modernize the law governing commercial transactions. 2. To permit the continued expansion of commercial practices through custom usage and agreement of the parties. And 3, to make uniform the law among the various jurisdictions. 3B states, unless displaced by the particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplement its provisions. And then it goes on to have an official comment that is a whole page and a half long. And it speaks about changes from former law. Then it talks about applicability of supplemental principles of law. Then it talks about application of subsection B to statutes. So that's just an example of how important it is when you go fucking with these people in these courts to know what it is that you're talking about, or they're going to hand you your ass. So, all right, so I'm going to get back to it. It says, some of the law libraries will only have the West Publishing version. I actually have the Thomas Reuters edition. Okay, 2017 through 2018. So I'm going to have to, update my shit. Stay up to date so they can't slide nothing in on, you know what I mean? So, all right. And it is very difficult to understand. In Anderson, it is broken down with decimals into 10-point parts. And most importantly, it is written in plain English. Okay. All right. Now we get to the part that speaks about recourse. All right. It says the recourse appears in the Uniform Commercial Code at 1-103.6, which says the code is complementary to the common law, which remains in force except where displaced by the code. A statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. This is the argument we use in court. The code recognizes the common law. If it did not recognize the common law, the government would have had to admit that the United States is bankrupt and is completely owned by its creditors. But it is not expedient to admit this. So the code was written so as not to abolish common law entirely. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights at 1-308, you may then insist that the statutes be construed in harmony with the common law. Very, very important shit that I'm reading to y'all, people. If the charge is a traffic, you may demand that the court produce the injured person who has filed a verified complaint. If, for example, you were charged with failure to buckle your seatbelt, you may ask the court who was injured as a result of your failure to buckle up. However, if the judge won't listen to you and just moves ahead with the case, then you will want to read to him the last sentence of UCC 1-103.6, which states, the code cannot be read to preclude a common law action. Tell the judge, Your Honor, I can sue you under the common law for violating my right under the Uniform Commercial Code. I have a remedy under the UCC to reserve my rights under the common law. I have exercised the remedy, and now you must construe the state statute in harmony with the common law. You must come forth with the damaged party. If the judge insists on proceeding with the case, just act confused and ask this question. Let me see if I understand, Your Honor. Has the court made a judicial determination that sections 1-308 and 1-103 of the Uniform Commercial Code, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he answers yes, then you say, I put this court on notice that I am appealing your judicial determination. Of course, the higher court will uphold the code on appeal. The judge knows this. So once again, you have boxed him into a corner. Practical application. Traffic court. Okay, this is going to, give you an analogy of how to put this in practical application in a traffic situation once it gets to court. Just so we can understand how this whole process works, let us look at a court situation such as a traffic violation. Assume you ran a yellow light and a police officer gave you a traffic ticket. Okay. Yeah, it's great. Okay, 1. The first thing you want to do is to delay the action at least 3 weeks. This you can do by being pleasant and cooperative with the officer. Explain to him that you are very busy and ask if he could please set your court appearance for about 3 weeks away. At this point, we need to remember the government's trick. I'm from the government and I'm here to help you. Now we want to use this approach with them. They're not your friends, so you got to use the same shit against them because that's the game they playing. So you got to learn the rules and play by the rules. Step number 2. The next step is go to the clerk of the traffic court and say, I believe it would be helpful if I talk to you. Because I want to save the government some money, this will get their attention. I am undoubtedly going to appeal this case. As you know, in an appeal, I have to have a transcript, but the traffic court doesn't have a court reporter. It would be a waste of taxpayers' money to run me through this court and then have to give me a trial date de novo in a court of record. I do need a transcript for appealing. And to save the government some money, maybe you could schedule me to appear in a court of record. You can show the date on the ticket, and the clerk will usually agree that there is plenty of time to schedule your trial for a court of record. Now your first appearance is in a court of record and not in a traffic court where there is no record. Number 3, when you get in the court, the judge will read the charges driving through a yellow light or whatever, and this is a violation of ordinance XYZ. He will ask, do you understand the charges against you? Now, before I go any further, a lot of people don't understand this. When they ask you, do you understand the charges against you, think etymology. He's asking you, do you stand under these charges? Okay? It is very important to get it read into the record that you do not understand the charges, with that in the record, the court cannot move forward to judge the facts. This will be answered later. Number 5. Well, Your Honor, there is a question I would like to ask before I can make a plea of innocent or guilty. I think it could be answered if I could put the officer on the stand for a moment and ask him a few short questions. The judge responds, I don't see why not. Let's swear the officer in and have him take the stand. Is this the instrument that you gave me, handing him the traffic citation? The officer, yes. This is a copy of it. The judge has the other portion of it. Where did you get my address that you wrote on that citation? Officer, well, I got it from your driver's license. Handing the officer your driver's license, is this the document you copied my name and address from? Officer, yes. This is where I got it. While you've got it in your hand, would you read the signature that's on the license? He boxing me, man. The officer reads the signature. While you're there, would you read into the record what it says under the signature? Officer, it says without prejudice, UCC 1-308. The judge, let me see that license. He looks at it and turns to the officer. You didn't notice this printing under the signature on the license when you copied his name and address onto the ticket? Officer, oh no, I was just getting the address. I didn't look down there. Judge, you're not very observant as an officer. Therefore, I'm afraid I cannot accept your testimony in regards to the facts of this case. This case is dismissed. You had reserved your common law rights under the UCC. That's A. B. You had done it sufficiently by writing without prejudice. UCC 1-308 on your driver's license. The statute would now have to be read on harmony with the common law. And the common law says the statute exists, but there is no injured party. And D, since there is no injured party or complaining witness, the court has no jurisdiction under the common law. Oh my goodness, this is golden information. Golden information. Now, I ain't saying to run out and get a ticket, but I'm saying, it's something good to know. Excuse me. Because myself, I'm a bluff caller. I like to appraise what a motherfucker's saying to me. So, the very next ticket I get, I will be, testing and measuring, this information for myself. You gotta have the balls or the fallopian tubes to do it for yourself. A lot of you people, a lot of us, as many gangsters and real bitchs we got, scared to death of the white man. You ain't gotta like it. It's a proven fact. Anyway, let me get into it. Okay. Number 6. If the judge tries to move ahead and try the facts of the case, then you will want to ask him the following question. Your Honor, let me understand this correctly. Has the court made a judicial determination that it has authority under the jurisdiction that it is operating under to ignore 2 sections of the Uniform Commercial Code which have been called to its attention? If he says yes, tell him that you put the court on notice that you will appeal that judicial determination and that if you are damaged by his actions, you will sue him in common law action under the jurisdiction of the UCC. Now we go to the questions and review. It says, note, there are some of the questions asked after the main lecture. Some of the restatements of material presented earlier, but they contain very valuable information which is worth repeating. Courtroom techniques. Question. How do you box the judge in? This is easy to do if you don't know too much. I didn't know too much, but I boxed him in. You must play a little ignorant. That's what he means by if you don't know too much. You see what I'm saying? You ask questions. You don't go in there with the riffraff. You dig what I'm saying? Anyway, if you are arrested and you go to court, just remember that in a criminal action, you have to understand the law, or it is a reversible error for the court to try you. If you don't understand the law, they can try you. Okay. In any traffic court case or tax case, you are called into court and the judge reads the law and then asks, do you understand the charges? Defendant, no, Your Honor, I do not. Well, what's so difficult about the charge? Either you drove the wrong way on a one-way street or you didn't. You can only go one way on that street. And if you go the other way, it's a $50 fine. What's so difficult about this that you don't understand? D, well, Your Honor, it's not the letter of the law, but rather the nature of the law that I don't understand. The 6th Amendment of the Constitution gives me the right to request the court to explain the nature of any action against me, and upon my request, the court has the duty to answer. I have a question about the nature of this action. J, well, what is that? What do you want to know? Always ask them some easy questions first, as this establishes that they are answering. You ask, well, Your Honor, is this a civil or a criminal action? J, it is criminal. If we were in a civil action, there would be no fine. So it has to be criminal. Okay, D. Thank you, Your Honor, for telling me that. Excuse me. Then the record will show that this action against whatever your straw man name is a criminal action. Is that right? J. Yes. D. That's the judge. D for defendant. I would like to ask another question about this criminal action. There are two criminal jurisdictions mentioned in the Constitution. One is under common law and the other deals with international maritime contracts under an admiralty jurisdiction. Equity is civil, and you said this is a criminal action. So it seems it would have to be under either the common law or maritime law. But what puzzles me, Your Honor, is there is no corpus delicti here that gives this court a jurisdiction over my person and property under the common law. Therefore, it doesn't appear to me that the court is moving under the common law. Judge. No, I can assure you this court is not moving under the common law. Defendant. Well, thank you, Your Honor. But now you make the charge against me even more difficult to understand. The only other criminal jurisdiction would apply The only other criminal jurisdiction would apply only if there was an international maritime contract involved and I was a party to it. It had been breached, and the court was operating in an admiralty jurisdiction. They definitely ain't going to admit that. I don't believe I have ever been under any international maritime contract, so I would deny that one exists. I would have to demand that such a contract, if it does exist, be placed into evidence so that I may contest it, but surely this contract is not operating under an admiralty jurisdiction. You just put words in the judge's mouth. Judge, no, I can assure you we're not operating under an admiralty jurisdiction. We're not out in the ocean somewhere. We're right here in the middle of the state of North Carolina. No, this is not an admiralty jurisdiction. Okay. Defendant, thank you, Your Honor, but now I am more puzzled than ever. If this and these charges is and are under the common law or are not under the common law or under admiralty, and those are the only criminal jurisdictions mentioned in the Constitution, what kind of jurisdiction could this court be operating under? The judge, it's statutory jurisdiction. Defendant, oh, thank you, Your Honor. I'm glad you told me that, but I have never heard of that jurisdiction. So if I have to defend under that, I would need to have the rules of criminal procedure for statutory jurisdiction. Can you provide me with the location of a copy? Yeah, so basically, man, that's the end of that part. Then, it gets into accessing your straw man account and filing a UCC 1 financing statement, of which I already have. If any of you guys are interested in doing so, again, research, read, reread, and reread again as many times as it takes for you to understand these things and how to properly apply them before you make that move. But based on that part that I wanted to read to you guys being complete, that'll conclude this video. And now I can move on to something else now that this is done. If anybody's interested in me reading how to access your straw man account and file a UCC 1 financing statement, put it in the comments, and I'll get into that detail for y'all, and I'll even share, my personal experiences in doing so. So with that said, man, hopefully this video gave somebody, a deeper level of understanding of the government of which we're, being governed by. Hopefully you guys have gained a broader and deeper understanding of what that entails. As always is my intent, to bring a broader scope of knowledge, understanding, and wisdom to my viewers. Just hopefully, man, you guys appraise me, appraise my word, appraise the things I read to you by researching and looking it up for yourself, man. Don't ever take my word, because it ain't me saying it. This is their stuff. And it's the only way that you can beat them at their game is to learn the rules and then play by the rules. Emotion has no part to play in it. It's all based off intellect. Bruce Lee told us a long time ago, you must learn to control your emotions, because if you don't, your enemies will use it as a tool against you. So with that being stated, man, y'all be easy. Good evening.